Thank you again to all participants joining. So just to say, this is an event with, we have 5 panelists, 5 guest speakers who will today with us discuss on access to justice for migrant workers in particular. And just for your information as well, at the end of this webinar, we have on the Fair Recruitment Knowledge Hub foreseen a discussion for a week with certain of the panelists who will be able, to answer to some of your questions if you didn't have a chance to ask for you. So please, for that, make sure to connect to the Fair Recruitment Knowledge Hub and to register, and you will be able to continue discussing with them for a couple of days. And also, let me mention something quite important. First, the event is recorded, so if you didn't have a chance to stay until the end, you will be able to watch the webinars at the end of, let's say from tomorrow, it will be available online, both in English and in French. And also, we have a chance today to have 2 colleagues from the ILO who will also be rapporteur. Let me first maybe introduce my colleague, Ratna Matei-Luke. So, good morning, good evening, Ratna. So Ratna, she's from ILO Bangkok and working on a safe and fair project on women migrant workers. So she will follow with you the discussion in the forum next week, and mainly focusing on gender and women migrant workers' perspective. So she will also, during the next week, say a little bit though on what she gained from this webinar. And thank you, Ratna, for that. And the second rapporteur is also one dear colleague, Kumba Diop. So who is the labor migration specialist at the ILO Regional Office for Africa. And she will follow up the discussion from the perspective of expanding works in this area, access to justice in the Africa region. Thank you very much, Kumba, from joining us from Abidjan. It's a pleasure to see you with us today. Without further ado, let me give the floor to Miss Michelle Layton. She's the chief of the ILO Labor Migration Branch. And Michelle, thank you very much for addressing the welcome word to our participants. And I give you the floor.
Thank you, Miriam. And let me welcome all of you to this roundtable today on access to justice for migrant workers. I'm really delighted to be here and to open this session as part of our peer-to-peer learning exchanges that are facilitated by ILO's Global Knowledge Hub on Fair Recruitment. Migrant workers, as many of us know, are some of the least protected in the workplace. And the global pandemic has shown us that labor migration governance in many parts of the world is still not sufficient to protect many of the 169 million women and men migrant workers who contribute significantly to our societies and our economies. Too many still face the risk of exploitation from poor wages or the withholding of wages, as we saw during the pandemic. They lack proper contracts, they lack labor protection, in many cases, including from occupational hazards and dangerous work. And because they lack social protection, even when they are injured, which results in the inability to work, they may be without resources. So it's no surprise that many feel insecure in their workplace. They're in temporary or precarious work, and too often they fear being deported, so it prevents them from raising concerns regarding non-compliance with labor standards. Even in some occupations, like domestic work, particularly women remain at risk because they're not even covered under labor law. The ILO has documented in too many instances that migrants face discrimination and risk, which can begin at the moment they are recruited into their job. And the weaknesses in labor migration governance systems across the world are some of the issues that were raised just recently at the United Nations at the International Migration Review Forum in New York. Now, one of the results of that forum was a progress declaration that governments adopted, recommitting themselves to the Global Compact, but also to issues of fair recruitment, which they believe deserved greater attention. In fact, governments committed to providing migrants fair recruitment under the Global Compact, but also rededicating themselves to providing access to information pertaining to their rights and obligations during all stages of migration, including information on fair recruitment, on skills, qualifications, entry and exit requirements, living and working conditions, wages and benefits, and access to justice. Now, access to justice, of course, continues to be at the forefront of ILO's concern as the leading UN organization on labor, but it's also a key issue for governments, employers, workers' organizations, and civil society. And your participation here today is a testament to your commitment to better understanding these issues and finding areas of good practice that we hope you can utilize in your own work. Now, I think we can all agree that the issue of access to justice is really central to making human rights, including labor rights, a reality for workers and individuals. And it's premised on the central tenet that every person is entitled, without discrimination, on an equal basis with others, to equal treatment and protection under the law. And we know that when people are protected under the law, they can still face not only administrative and legal barriers, but practical barriers to accessing remediation for any exploitation or abuse that they suffered. And this is why the ILO's Fair Recruitment Initiative and the new strategy that we adopted for 2021 to 2025 is committed to exploring and supporting these exchanges with you and with many others to help us really move the global movement forward and ensure that migrant workers' rights are protected, but actually enforced, including through their own agency and justices that migrant workers themselves seek. The ILO's Fair Recruitment Initiative now has an advisory committee made up of the social partners and government representatives. And let me just say that thank you to Italy and Mexico for co-chairing the steering committee, our advisory committee. And during the last meeting, there was great consensus that access to justice has to be a key priority. Recruitment should be conducted in ways that recognize and respect and protect international human rights and labor rights. So workers need access to justice to make sure that that happens. And today we are launching the background paper to this event, Fair Recruitment and Access to Justice for Migrant Workers. And this roundtable really brings together, and I'm very pleased to see, a distinguished and diverse group of panelists who are going to discuss some of the lessons, their findings, and ways forward that we can ensure better access to justice. Let me close by saying that this roundtable is really part of a full series of discussion around fair recruitment under the Knowledge Hub within our initiative. And the recent activities have included peer-to-peer exchanges on enforcement of fair recruitment through labor inspection, research, and exchange on digital technology to protect migrant workers. And coming soon, we're going to host a dialogue to explore addressing irregular labor migration and protecting the rights of migrant workers in an irregular situation. We're also going to explore key issues, fundamental principles and rights at work, such as freedom of association and collective bargaining. Now, the ILO's Fair Recruitment Initiative, which sponsors this global knowledge hub, really draws on lessons from work that we're doing, many of you are doing, in over 30 countries on areas like police reform, enforcement, policies and legislation, women and men's empowerment, and fair business practices. And we're going to continue to host these series and discussions and further issues to foster greater knowledge and understanding and to scale up the work that all of you are doing so that we can have fair recruitment for all. And we very much appreciate today if you would share your experiences on what's the most impactful areas of work, how we can improve the scalability of the lessons that we're hearing. And we're encouraging you to be an active participant in the discussion and afterwards to really be an active contributor to our Knowledge Hub. I now will hand the floor over to Miriam Boudra from the ITC ILO, who was just speaking to you, to introduce the agenda and the panelists. But before I do, let me thank her and the great Fair Recruitment team in the ILO Heike, Maria, Melanie, and Kumba, nice to see you here, and others who really made this series possible. I'm really excited for today, and I wish you a fruitful discussion. So thanks, and over to you, Miriam.
Merci. Thank you very much, Michelle, for your nice welcoming word. I hope you can stay with us a little bit. I know that you have other meetings that you have to join, but thank you very much for always ensuring to be there for welcoming our participants with the warm message. As you rightly mentioned, let me introduce you our panel of expert speaker or panelist of the day. I have to say that I was very excited when I see the names that was joining, and I was very excited to know that I have the chance to exchange and facilitate discussion. So I hope participants will have a possibility to ask questions and to very much appreciate their thought and their intervention. So let me first start to introduce you Mr. Mustafa Kadri. Mr. Kadri is the Executive Director of Equidem Research and Consulting, a human rights and labor rights research and consulting firm. Equidem has developed the ILO working paper on fair recruitment and access to justice. So thank you very much, Mr. Kadri, to be with us today. And we are really looking forward listening some of your findings, and I'm sure participants will have a lot of questions for you. We also have the chance to have Mr. Dr. Jivan Bania, who is the Assistant Director of Social Science Baha Research Institute in Nepal, that has been carrying out social science-related research, including on the issue of labor and mobility. So if I'm not mistaken, Social Science Baha, in collaboration with ILO, has carried out the research on ensuring access to legal support for migrant workers for violation in the recruitment process in Nepal. And the report is, if I'm not mistaken, is going to be published very soon. So Dr. Bania will let us know more about this paper. Then our third panelist will be Ms. Suriya Nanhini. I hope I pronounced it well. She's a national coordinator at the Migrant Research Center for the Malaysian Trade Union Congress. She's a lawyer by training and has been involved in the Migration Research Center for almost 3 years. The center is a team of 5 officers in the central, southern, and northern regions, and serve migrant workers from Peninsular Malaysia, Sabah, and Sarawak. The scope of work includes awareness raising, case management, training, and organizing workers into trade unions. And she will, during this webinar, explain a bit more the work done by the center and her experience as well within the center. Then our fourth guest would be Mr. Douglas McLean. He is the Executive Director of Justice Without Borders, a regional non-governmental organization based in Asia that creates transnational access to legal assistance for victims of labor exploitation and human trafficking, with a focus on seeking compensation for workers even after they have returned home. So Justice Without Borders work across Hong Kong, Singapore, Indonesia, and the Philippines. And last but not least, we also have the chance to have with us Ms. Vidhi Agarwal. Hope I pronounce it well. She's the lead on labor and human rights program at Apple. Within this role, she's focused on prevention and of involuntary labor across Apple manufacturing and service supply chain. In her 10 years of experience at Apple, she has been responsible for creating innovation solutions to enable Apple's commitment to responsible and fair recruitment in implementing Apple's zero recruitment fee policy. She also represents Apple at the ILO Global Business Network on forced labor. So thank you to our 5 guests to be with us today. And let me directly launch the discussion. And maybe Mr. Kadri, start with you. You recently worked with the ILO to publish a discussion paper on access to justice and fair recruitment. Can you maybe provide us with a brief overview of the most salient features working paper? For example, how does the paper arrive at shared understanding of the meaning of effective justice in the context of recruitment abuse against migrant workers? I maybe give you the floor to answer to my first questions, and I still have some questions for you after that.
Sure. Firstly, Miriam, thank you so much for having me on this panel and also getting myself and Equidem involved in the paper. It's a real pleasure to speak to you all. And like others have said, really look forward to learning from the other speakers. So as Miriam said, I wrote a paper for ILO on access to justice for migrant workers. And your question around what does it mean to be effective is really key. Because in fact, many of us for many years have been really desperate to get the attention focused on the recruitment aspect of access to justice, because as many of us know, it is where often the cycle of exploitation, the risks to these workers can commence. And it is often very hard to get justice for that aspect of any issues that are faced as compared to other things. And as others have mentioned, in fact, across the board, migrant workers are very generally disenfranchised and they face challenges. So in terms of firstly answering around, what does it mean to be effective in terms of access to justice? And then very briefly talking about the report. I think it's very useful to talk a little bit about what actually, our attempt in the paper to define the term access to justice. Now, access to justice is central to making human rights, including labor rights, a reality for all workers and individuals. And as other speakers mentioned earlier, one of the central tenets of that is the concept of non-discrimination, that everyone is entitled without discrimination and on an equal basis to equal treatment and protection under the law. Now, of course, international conventions and even the UN guiding principles on business and human rights under Pillar 3 talk about access to remedy for victims of human rights abuse. And so this is something that's very much enshrined in international law, but there are huge gaps there when it comes to not only migrant workers, but also to access to justice. So when it comes to being effective, certain indicators come from international law and international standards. And those things include that it must be accessible, affordable, adequate and timely. It must combine preventative, redressive and deterrent elements and include the right to be treated equally in all stages of procedure, regardless of personal characteristics such as gender, race or ethnicity, among others. And so what we did with our report, obviously, was to focus on that as the premise for what's our benchmark for an effective way to provide access to justice with respect to recruitment. But what we did was to really outline in the three broad ways what are the barriers to justice, and then at the very end of the report, really talk about what is the best practice that has allowed governments, businesses, trade unions, and other stakeholders to address that. In terms of those barriers, very broadly, of course, those fall into three main categories. The first is legal barriers. What this typically means is migrant workers may not be adequately protected under relevant laws and regulations or are otherwise excluded from that coverage. Another barrier is accessibility. So there may be legal protections, but migrants may not be able to effectively utilize those remediation mechanisms for a variety of reasons. It could be a lack of language skill, inability to meet legal fees, lack of understanding of their country's legal system, length of proceedings, and other things like that. And of course, there are social factors as well, such as discriminatory attitudes of public officials that may reduce the opportunity for a fair outcome. The third barrier is around enforcement of measures, and that means decisions and penalties may not be properly implemented, especially after migrant workers have returned to their home country. So we talk about that in the report, and then we dive straight into the types of good practices that are available. I'll leave it there to go into more detail. Imagine, Miriam, you want to interrogate that a bit more, but just to say that we tried our best to, in that process, really outline what we feel were, even if there were specific aspects of that access to justice journey for migrant workers, the good effective practices that come mostly from states, while also recognizing that there are multiple stakeholders in government, amongst labor recruiters and employers and of course, trade unions and worker organizations that are critical to ensuring workers get access to justice with respect to recruitment processes. But what we did then was to go into detail about those different aspects. But I'll leave it there, Miriam, for you to follow up.
Thank you very much, Mr. Kadri. And indeed, I think as you rightly, we already understand, and you expose it well a bit, the methodology you use for assessing some good practice. And indeed, can you maybe let us know a bit more about the numbers of emerging good practice you highlighted in the paper, the methodology, you already say a little bit on that for assessing them, but also the limit of this approach. Did you find some limits as well in the work you have conducted?
Yeah, really great questions, Miriam. So obviously, obviously this is a very challenging, sobering issue that we're discussing, but it was also very exciting to work on this because it was about framing the issues around solutions. And myself and Equity are very, very much about not just identifying problems, but what are the solutions. And so for me, that was really exciting. And you're absolutely right. There are limitations, as I'm sure everyone is aware, on this panel right now. There are limitations to everything that I'm saying and I'm about to say. There's no attempt here to say that we've resolved these problems. Much more work is needed. But in terms of the types of good practice that are there, and then I can talk about some of the limitations, what really struck me was that there actually is movement in every part of the world, in several countries, particularly countries of destination, the countries that workers are going to work, to address, particularly to do with recruitment, the need for access to justice. For me, that's a very positive thing. But also, when you read the report, I hope it's very clear that other stakeholders in business, amongst trade unions and civil society, we have to build on that. We can't just leave it to governments alone to address these things. So some of the good practices that we outlined quite a few. So I'll go through these very, very quickly, but I'm very happy to expand on any of this. Is, for example, new legal directives and progressive court rulings in several countries across geographies and continents to allow certain frequently excluded categories of workers, like domestic workers, undocumented workers, and gig workers, to access justice on the same footing as other categories of workers. We also saw in some countries of destination that they've established mobile labor courts, one-day courts, and other administrative mechanisms with clear timelines for mediation and legal action, which are reducing lengthy waiting periods for migrant workers who have filed claims seeking redress. Now, other countries of destination also now allow migrant workers to stay in country and work for a new employer while they await the resolution of claims made against their former employer. In addition, some countries have shifted the burden of proof in disputes concerning the payment of wages or recruitment issues, so that employers now need to prove that they indeed pay what they owe to the complainants. Some countries have sought to address concerns over employers and recruiters retaliating against migrant workers who have filed complaints. A number of measures along these lines have been taken, including the passage of legislation that prohibits and punishes retaliatory actions by employers and allows workers to file anonymous complaints at dispute resolution bodies, and the creation of safe houses to defend workers at risk of reprisal. Now, of course, countries of origin are also really critical to the picture, and some have established joint and several liability systems that peg the responsibility of recruitment abuse on the recruitment agency, which is treated as a co-employer, which I think personally is a really fascinating concept. And this allows migrant workers who have suffered abuse to receive restitution that would otherwise be impossible to claim, because obviously the employer is outside the jurisdiction of the domestic courts in the country of origin. In addition to the aforementioned legal remedies, the increasing use of digital documentation of worker contracts and wage slips helps workers to provide evidence of abuse suffered, and many states have created and promoted toolkits that aim to engage and inform migrant workers about their right to access justice. And lastly, there are efforts being supported by trade unions and other work organizations that allow for legal awareness and for legal professionals to support workers. Things like the Rate Your Recruiter mobile apps for migrant workers, websites that support rights awareness, and also trade union-led migrant resource centres. A range of other initiatives have also been created for workers to address these issues. Very, very briefly, in terms of the limitations, I think in many respects, these will be obvious. In terms of the legal architecture, one of the main limitations that we touch upon briefly in the report is that we're talking about a transnational regional issue when it comes to recruitment related issues. And often workers, of course, transit through one or more countries on their way to the country of destination. And so we don't have, for example, adequate treaty architecture to allow for, the international system, let alone governments and regional bodies, to address situations where there might be violations, breaches of law, or on the positive side, compliance requirements on employers and regulators that could be enforced. And that's something that we really have to look at. The other thing is that for workers, these issues are so mixed in with other issues that they face that there can often be evidentiary issues around how you actually get redress. So that, for example, workers may be charged an illegal fee for which there's simply no documentation. And so that's why a simply legalistic approach to these issues is not always satisfactory, because there needs to be another approach to dealing with these issues where the evidence base or the legal case is not there. And very finally, very, very briefly, although I think there's a lot more to unpack in this, is the phenomenon of the transnational business character of modern recruitment, which is to say that often the way that recruitment starts is actually in the country of destination, and that itself is not adequately regulated with respect to how orders are made for people from certain countries and regions. And that also touches on issues around discrimination, that workers from different nationalities or certain backgrounds might actually get paid less for the same job, and that often recruiters and businesses and other actors can blame it on the labour market. And there's a real lack of an attempt to really address that. I think that's an area where businesses can really work very closely with government and worker-led organisations to seek to address that, particularly given nowadays the advances with technology and being able to track, high volumes of data in a way that we couldn't before. Obviously, I really want to stress there's a lot more in the report than what I've said. There's a lot to unpack in that. It's obviously very difficult to really unpack that in a short call, but those are some of the things that we outline in the report. And again, really enjoy working with the ILO on this really important piece of research.
Thank you very much, Mustafa, for your. It's quite challenging in 10 minutes, to unpack a report which is so many full of information. But I think it's very interesting indeed how you mentioned, that yes, of course, access to justice. It's very challenging. I mean, say in general, but we see from what you say the specificity, as well, faced by migrant workers, and I think you rightly mentioned, this transnationality aspect, in particular in the recruitment, that might even make access to justice even more complicated. But I also think, listening to your intervention, that there are some very promising practices, and I will keep in mind, for instance, you highlighted the mobile labor court and reducing the length, because I think we also have to consider the temporariness sometimes of contract of migrant workers, and they stay as well in the country of origin or destination. Sorry. So I think this is kind of very promising practices, and for sure we will hear more from you in the discussion with the participants. I really encourage participants to ask you questions using the Q&A, and for sure you will tell us more in the discussion later on. I think you already highlighted the role that could be played by workers and employers. We have Surya from MTUC that clearly will also share the perspective from the workers, and then later as well, I'm quite sure that through VD, we will also hear from the perspective of employers. So it's very interesting indeed to know as well what could be done by trade unions and employers. So thank you very much, Mustafa, for this very inspiring 10 minutes. I know it was challenging, but I'm looking forward exchanging more with you later on with during the Q&A with participants. Let me maybe now give the floor to Dr. Jivan Bania. And you also has worked lately with the ILO, and particularly in the case of a report that will, as we mentioned at the beginning, is going to be published soon on ensuring access to legal support for migrant workers for violation in the recruitment process in Nepal. So my first question for you, Dr. Bania, is how can a decentralization of justice mechanism increase access for migrant workers and reform of the recruitment industry as a whole? Can it support increased access for any group in particular? Can it make the process quicker, less costly? Is localization of the process more suited to certain type of cases? So that would be my first question for you, Dr. Bania.
Thank you, Mariam. Thank you, everyone, particularly from the ILO Fair Recruitment Projects and all the participants. I mean, I completely agree what Mustafa mentioned about the access to justice being the cross-border issues, and then we need kind of cross-border access to justice mechanism if we were to provide access to the migrant workers. But in today's discussions, I will be basically focusing on the findings from the study that we had conducted recently with the support from the ILO. I'm trying to organize my thought around three different areas. First, in that particular study, what we tried to do was to identify type of problems that migrant workers face in relations to the issue of access to justice. And then we also tried to look at the kind of challenges and opportunity that we have in terms of accessing justice and providing justice and various kind of services related to that. And then maybe in the discussion, maybe we can come back to the way forward. So first of all, if we look at the case of Nepal, including the findings of our study, and many of the studies suggest that many of the migrant workers from Nepal are facilitated. Their migration is facilitated by the private recruitment agencies.
Sorry, Dr. Bania, can I just interrupt you 2 seconds? Sorry for that. I just realized that your camera is off.
Sorry.
No,
okay.
no problems. I just find it would be nicer to follow you.
That's fine.
Thank you very much.
I was coming to the point that before we talk about the access to justice issues, we need to also be aware of the kind of challenges and the problems that the migrant workers face. In terms of the Nepali migrant workers, our study and many of the other studies have suggested that nearly 90% of the migration from Nepal is facilitated by the private recruitment agencies and sub-agents. Even the Nepal government has prohibited the operation or the facilitation of migration through the individuals or agents in the recent year. I think it was in 2018. Most of these migration is facilitated by these both the actors, sub-agents and the private recruitment agency. If you look at the major problems that the study has identified, it's basically the overcharging of the fees. It's quite hefty, and there are a lot of deceptions on the contract, including the contract substitutions. And in some of the cases, the passport of the aspirant migrant workers have been seized and they haven't been facilitated for in the migration process. Other issues, maybe Mustafa has already highlighted about the kind of exploitations and labor rights and human rights violations that they undergo in the destination's country. I don't want to go into detail, but the issues are related as well, because the Nepal government has also come up with the policy, the Act, Foreign Employment Act, that if any migrant workers is subjected to the labor rights violations, contract violations, and human rights violations in the destination's country, the particular act has the provisions to register those cases here in Nepal as well. Although the implementation is very weak, but the provision in the act is there. So, they have been also subjected to labor rights and human rights violations in various destination countries, including a critical issue of withholding of the passport by the employers. In one of the studies, I think the ILO supported that initiative, the MRA, Migrant Recruitment Advisory. In that research, I was involved in the analysis and writing of that report that suggests that 95% of the migrant workers' passport was withheld by the employer. So, we are talking about the rights. There are various rights, including the right to keep their identity documents so that they could avoid exploitations, and they could also enjoy right to change the employers or to return to Nepal in case of COVID and other exploitative situations. But that's the case. So there are issues like this. One of the pertinent issues I think the Nepali migrant workers have been facing is the hefty recruitment fees. If you look at the various studies done in the past 3-4 years, despite the fact that the Nepal government has introduced and implemented what they call the free visa and free ticket policy, so that provides that lets the private recruitment agency charge around $8 to $10 as a recruitment fees, that particular policy. But if you look at the implementations, migrant workers have been forced to pay around, minimum of around $40 US to $2,500 US, especially in the case of the semi-skilled and high-skilled migrant workers. The fees will be also even much higher. And then, as Mustafa was saying earlier, they're not provided with the receipt and the evidence of what they paid. What they provide is just the receipt of that minimum fees that the law has allowed. So that issue is of critical importance here in the case of migrant workers. I also looked at that. We also looked at that study that many of these migrant workers have also returned to Nepal because they couldn't find a job in the destination countries, especially because that their migration was facilitated by the placement agencies, or what we might even call the supply companies or something like that. And in that study, we also tried to look at whether they have reported their grievances or not, or they have registered those grievances or not. Many of them do not register. Almost 80% of them have not registered or any grievances in Nepal. And then we asked why that was the case. And there are several factors. One of them is a lack of information about the legal procedures and the complaint mechanisms that are available. I think Mustafa had also highlighted about it. And in many cases, I think we are also talking about the evidence, lack of evidence. In many instances, migrant workers even don't know the institutions and the individuals that they facilitated their migration or they were employed by. So lack of evidence is another reason why they don't report and register their cases. And there are also issues about the cost that is associated to follow the legal proceedings, and the cumbersome and lengthy process. The judicial process is another reason that many of the returning migrant workers subjected to various kind of problems reported. And for various reasons, I think that they also have lack of trust in these institutions. That's why they don't go to those institutions. And some of the migrant workers that we spoke with also suggested that they also fear of retributions and fear of arrest and kind of retaliations from the perpetrators. Hence, they don't go to these institutions. let me give you a recent study that was done by the People's Forum. I think it came yesterday. It's quite interesting, and it is also in line with the findings of our study that the People's Forum had provided legal service to the total number of 28,054 migrant workers, and almost half in half cases, it was the private recruitment agencies were involved, and half were individuals. But out of total 1,692 cases registered in the legal system, only 70% were adjudicated. So that is quite evident to tell us about the situation of the legal proceedings. It's quite lengthy, you know. The process is quite lengthy. You had the questions about the alternative dispute resolutions that was in practice in Nepal at some point of time, but unfortunately that couldn't proceed. That particular process was underway, but there was the change in the Director General in the Department of Foreign Employment. Hence, that process stalled. And then I think no such dispute resolution process has proceeded. However, in the Department of Foreign Employment, there is this informal system of dispute resolution, although that is not mandated by the law. And you can imagine why that when both private recruitment agencies and individual migrant workers or their families would go to the department in order for the dispute resolutions, because that process is quite lengthy. Migrant workers don't have time and resources to follow the cases, so hence they go for the quick fix. And the private recruitment agencies would also don't want to go through the whole legal procedures, and they have also the fear of being penalized. So they also prefer some kind of mediations and settlement in the DOFE. That is through the informal setting that has been going on. But in our interviews with the migrant workers and the private recruitment agencies, I think they prefer that. We have to think about whether or how that kind of system could be or should be in place, especially in the context of Nepal, where access to these institutions for the access to the justice is quite challenging. I think that kind of mechanism at the subnational level and the local level could be quite crucial. Especially lately, the CDO, the district level, the Chief District Office has been provided with that mandate for the mediations of some of the cases which are of civil nature, but not the criminal nature. They've been trying to have the mediation on the grievances that is registered by the migrant workers. However, in our research, it was identified that we have this system that was introduced here in Nepal, the federal governance system that started since 2017, that these offices are quite overwhelmed by other businesses, and they have less time and resources and the capacities to support the migrant workers' issues. So hence, the whole system it's not functioning well, or it has not been effective. Nevertheless, recently, the institutions like Migrant Resource Centers, which is supported by the Swiss government, and there are also NGOs like People's Forum and other NGOs which have been providing that kind of support to enable the migrant workers or their families to register those cases in the city office, at least. And some of those cases are also referred to the Department of Foreign Employment and other relevant agencies. So in that sense, it's working a little bit. With the new governance system in Nepal, we have this justice committee at the local level, municipal level. And recently, I think many of us have been following the news that there are a lot of migration related or recruitment related grievances registered in those committees. They don't have the legal mandates to mediate or settle the disputes according to the law. What they need to do is to refer those cases to either to the city office or to the Department of Foreign Employment. However, again, in the cases of CDO, these are the local institutions that are also overwhelmed. They don't have technical know-how as to where to forward and how to deal with those cases. Hence, again, the issue of capacities, awareness, sensitization is there. I think I second with what Mustafa highlighted about how we can use the digital platform or digitization in order to register cases at the local level and then settle these cases through the digital platforms as well, so that the migrant workers and their families don't have to visit to the capital city or major cities of the country that incurs a lot of time, resources, energy, and things like that. So I can come back to other issues in the discussion session.
Thank you very much, Benya. Can I ask you to leave your camera on just for a moment? Thank you again. Thank you very much for intervention. Very clear, and it's quite interesting to see, indeed how many of the aspects you mentioned for the case of Nepal make echo to what Mustafa just mentioned before in his presentation. And I will indeed also take from your, you say that, I think it's quite interesting what you say with the role play, at the local level and the Justice Committee, and how indeed to bring also access to justice at the local level to, as you rightly say, that dimension, avoid for migrant workers a cost of, sometimes to go through a bigger city or at the capital, because indeed it's an additional cost and might in fact also lead to impact access to justice and refrain access to justice, or refrain, I would say, even maybe going through the process if there is the need of going at the national level. I also would take from you say the informal dispute resolution system that is sometimes, if I understood clearly, even preferred by both sides. And because it's maybe quicker and it might be even easier to fix that. So that is also something very interesting you mentioned. And as in fact, Mustafa mentioned at the beginning, the role that could be even played by, as you rightly said, trade unions, and you mentioned the migration resource centers, and we will hear very much on that in a couple of minutes. And the digital platform and the role that indeed digital tools can play as well in today our society, and to also facilitate access to justice. Thank you very much, Dr. Bainia. We will clearly hear more from you in the Q&A. We already started to have many questions from our participants, just for our participants, because I'm also having a look at the same time on the Q&A. If you do have more comments, general comments you want to share with, and particularly the other participants, please, in that sense, use the chat box, because basically Q&A can only be seen by the panelists. So any comments or more general comments you might want to share with the audience, please use the chat instead of the Q&A, and keep the Q&A for the questions you actually really want to ask to our panelists. Dr. Bania, we will continue discussing in a moment in the sessions on Q&A, but let me now turn the floor to Ms. Suriya Nanhini from MTUC. So Suriya, you heard from both our two speakers indeed, that emphasize the role that could be played by the trade unions. And so I would really much to know from your side, and please share with us the role of the migration resource centers in Malaysia, how they work, and what are the strategy you decided to employ. If you can maybe share any recent case study, whether it's a success or a failure, including on securing access to justice in relation to the role of subcontractors, as indeed being an important actors in the recruitment process. So yeah, thanks again very much to be with us, and I give you the floor.
Hi, thank you, Miriam. Good day to everyone. Thank you so much for having me here. My name is Surya. I am the coordinator of the Migrant Resource Center that is currently attached to the National Labour Centre in Malaysia, which is the Malaysian Trade Union Congress. So the unique thing about this MRC, so there are many MRCs all over the world, and there are few MRCs in Malaysia, but the MRC that I'm heading is special in nature because we are fortunate enough to be attached to the National Labour Centre, which means whatever issues that we face and whatever issues that we bring up, we are able to directly bring it up as a tripartite constituent when we have social dialogue at a policy level. So that is, I would say, one of the greatest advantage of this MRC. In terms of the role that we play, so as introduced earlier, I think Miriam did say the 4 objectives. So this project actually has 4 simple objectives: is to raise awareness, is to manage cases, and to assist migrant workers as and when they reach out to MRC, to provide training for the migrant workers. That means we actually train the migrant workers to teach them what are their rights in Malaysia, what are their rights in general, what are the do's and don'ts. We focus on financial management, labor rights, how not to get scammed. We actually have a module on that because we realized that a lot of migrant workers fall prey to a lot of scam artists. And finally, one of the most, I would say, unique objective is actually organizing migrant workers into the trade union. When we say we are organizing the migrant workers into trade unions, ultimately we know and we feel that the trade unions are a long-term protection for the migrant workers, despite the fact that they are in Malaysia only for a very short while. In terms of the strategies specifically, I would like to mention one that I think it was thanks to COVID. I mean, it came to life because of COVID, because we had no choice. So the thing about Malaysia is that we had multiple lockdowns, so we could not reach out to the migrant workers at all, but we knew that was the precise at the I would say the rise of the pandemic, that is when the migrant workers face the most amount of problems and issues. So we actually started an online platform. We used Facebook and all its features and algorithms to assist us to reach migrant workers. And we are happy to report that it's been a success because we managed to get into, I would say, the individual phones of the migrant worker where they are able to access us, because true enough, many migrant workers lost their job overnight. Many were without job and food and shelter within the first month of the pandemic. So we faced a major issue, and there was a lot of panic because the whole world was suffering with COVID and they could not go back. And suicide rate increased. It's very unfortunate. So it was a scary time for everyone, but I would like to highlight that it was very scary for the migrant workers. I mean, if we thought we had it bad, they had it much worse, and I saw that firsthand. And we did our best to serve the migrant workers. To narrow into the discussion, so we are talking about recruitment and access to justice. So earlier Miriam asked me to share maybe a few case studies. So we have issues when it comes to subcontractors. We receive cases that are from workers who are on the construction sector. they tend to reach out to us, and about 80% of the time the issue is unpaid wages. And the reason why the wages are unpaid is because the issue of subcontractor is that, i.e., the money is not from the main contractor. So sometimes they have a contract of employment with the main contractor, but the main contractor does not manage the workers directly. Subcontractors is managing them. So the I would say the details of the work hours and the overtime is all with the subcontractors. So they actually are in charge of paying the migrant workers. And what happens a lot of times when, as we know, the payment always has to come from the main con and go to the subcon. And when it does not go to the subcontractors, then the workers tend to suffer. So there was a time where they did not receive payment for 2 or 3 months, especially because of COVID, because all construction in Malaysia came to a halt. We could not proceed with construction, and because there was no work, no payment was provided. Although technically that's wrong, because there was no, our government did not allow for salary deduction or termination of employment or suspension of payment of wages of any sort. Actually, our Prime Minister came up with a statement and said that to your best of ability, all employers are to pay the employees, and only under special circumstances are the employees allowed to sign a letter of consent to maybe defer the payment, not completely, I would say, not receive any payment or a complete pay cut. Those things were not allowed. But of course, migrant workers, being the most vulnerable group of people, they were completely exploited. So we received these kind of cases a lot, and in these cases the issue was the factors that influence whether they have access to justice is, number one, whether they are documented or undocumented workers. So the moment they are undocumented workers in Malaysia, it's really difficult. Only recently our Court of Appeal has affirmed that an undocumented worker can go to the Labour Department and file a case, but prior to that it was not allowed. This just happened like 2 months ago. So there's no access, just zero access, absolutely no access to justice. So MRC plays an important role as actually a mediator, and it's called informal mediation. So basically it's just calling the employer and having a sit down and talking. And sometimes we had to balance, I would say, the issues, because the COVID did affect the employers very badly, and especially in the construction sector, I think it's a no-brainer. So when they say that they have no money, it is not false at times. At times it's false, at times it's not. And a lot of times it was not. So we had to make arrangements for, I would say, even installment plans, and follow up on a monthly basis whether the worker has received the payment. Because at the end of the day, the worker just wanted to receive the remaining sum. They didn't have any other claim. They didn't want to fight with the employer. In fact, they most of the time, they don't want the MRC to reveal their identity. So usually if it's a large group of people, we do not reveal the identity. But if it's a one person claim, it's really difficult not to reveal the identity, because then we would not be successful in our claims. So if the workers are documented, then it's slightly easier. It's only slightly easier. But then again, the issue is there is no chain of causation. There is no link between the workers and the subcontractors, because usually the contract is the main contractor, and we cannot link the workers back to the subcontractors. So when we cannot link the workers to the subcontractors, it's really hard to claim the money owing legally. Again, informal mediation comes in. So earlier, I think it was mentioned that sometimes you have the access to justice, but that does not mean you have access to justice. It is there for namesake sometimes. Unfortunately, I know it sounds a bit harsh, but it's really namesake. It's on paper, but it doesn't work in reality, because we are doing the work on the ground, and we can see that it does not translate to a solution for the migrant worker. In fact, sometimes it is actually a hindrance, and it's actually a source of stress and concern, because what tends to happen is that their passports and their permits are overly reviewed, and we have had cases where really, I would say, unscrupulous employers have tried to exploit the workers in terms of purposely not renewing the permit, which automatically makes them undocumented workers. So a lot of the workers became undocumented worker, not by their own fault, not because they crossed the border and came into Malaysia illegally. Most of them become undocumented because of some other circumstances, and usually the circumstances is caused by either the employment agencies or the employer himself. These are the two parties. Yes.
Thank you very much, Ria, as well for reminding us also the reality from I would say from the field, and indeed some of the specific and very concrete case you are meeting. And I think it's interesting how when you said, when you're presenting, you highlighted as well how the pandemic actually also shown and I would say put in the spotlight as well the vulnerability of migrants and the loss of job, the loss of salaries as well that they faced, and therefore as well how it is indeed important to have access to justice. But as you rightly highlighted, sometimes it's not about having access to justice as such, but it's complicated in practice because also of the many subcontractors that might exist. And so indeed, I think with your intervention, we clearly see the many challenges faced in practice for making access to justice a reality for migrant workers. I just have, I'm conscious about the time, and I have one challenge for you. It's in 1 minute to answer to maybe, I would say, an additional questions, very much on how does the MTUC work through the Migration Resource Centers contribute into the role in social dialogue reform at the national level? So have you seen something happening, and does it contribute to enhance as well the social dialogue and or policy reform that might happen at the national level?
Thank you, Miriam. Yes, definitely. As I mentioned earlier, because we are very unique with a special MRC, and I've had the privilege of many times representing the Labour Centre in itself in discussions related to migrant workers at a policy level, basically sitting as the tripartite and contributing my ideas, because we have experience from the ground, so we can directly link it back to the law and see what needs to change and what are the policies and regulations that we need to implement, and what are the methods of sometimes execution. Sometimes the law is there, but currently maybe the method of implementation does not suit our situation. So I'm able to directly take whatever work that I do with my entire team and present it to MTUC, or at times even represent MTUC at the national level to speak about these issues. And what I tend to do is that I gather, because we attend many meetings, so I also take everything that all the MRC say and what ILO says and what the NGOs and CSO says, and I compile everything, because I'm given the opportunity to speak up on these matters, right? So that is actually a direct link over there. And recently, in Malaysia, we have launched the National Action Plan Against Forced Labour, and MTUC actually sat as the tripartite constituent, as the workers' representative, and I was part of the technical committee, and it was immensely helpful for the committee that we know what we're talking about, because sometimes representatives do not have the real life experience working with migrant workers. Maybe they only know it theoretically, but we know it by experience. So that lent to us highlighting a lot of issues, especially about recruitment fees and access to justice. So that is our contribution. Thank you so much.
Thank you very much, Surya, and already some questions for you in the Q&A that we will come back to you on that during the discussion with all the panelists. And looking at the time, we are like 10 minutes a bit late, but so I would try to make sure that the next intervention might be even be a bit shorter, even if very very interesting. So I don't want either you to run for sharing your experience. And I just want to indeed thanks our two last speakers to also be with us. And so Douglas and Vidi will address the issue of recruitment fees and cost, specifically looking at how this can be remediated through different strategy from the perspective of individual case work. So this will be done by Douglas through the work done by Justice Without Border, but also through the company level remediation policy. And Vidi, you will let us know more on what Apple is doing on that aspect. So maybe Douglas, let me start with you. Justice Without Border focus on the concept of transnational access to justice. And this has been already mentioned in the intervention by Mustafa and by Jivan as well. This aspect, this transnational aspect, we see how important it is. So you clearly focus on the concept of transnational access to justice and enable case to proceed through once the workers also has returned in the country of origin. Why is it so important that and how is it? How do you achieve that? Once the migrant return back in his country of origin. Over to you, Douglas.
Wonderful. Thank you so much, Miriam. Thank you to my colleagues at the ILO FAIR Initiative as well for this opportunity to speak and for our partnership on the project we engaged with them. So to your question, why is transnational access to justice important, particularly for people who are returning home? Now, thankfully, Mustafa, Jivan, and Surya have helped to answer these questions already, so I get to narrow this down a little bit. For our participants here today, let me give you context, and then let me get into the details as to why and then how we go about doing so. So our NGO is based over in East and Southeast Asia, where the ILO has reported that about a third of the value of the worst forms of exploitation take place globally. So we're working in a very large hotspot here. Key issue that's not unique to here at all is that when a worker goes home, they quite often lose access to any sort of claims, whether it's civil or criminal. Now, we're focusing on the civil side. One of the things that we've seen in this region is generally when somebody does go home, that's it, they're done. So when we started Justice Without Borders 10 years ago, we wanted to take this from the extraordinary of a worker actually going home and holding somebody who's exploiting them accountable to the ordinary. And to make that whole process as efficient, effective, and affordable as possible. Now, Mustafa has done a fantastic job of highlighting so many of the different issues of which ours is a part. And so I really do want to highlight that we're just focusing on one small piece here. And our intervention really is about that access to justice through civil compensation. Many other issues, but this is where we feel we can make the greatest intervention. And a lot of this comes out of previous UN research that shows that after their health and their safety, most workers need compensation in order to get back up on their feet and to perhaps escape the cycle of debt bondage that far too many people happen to be in. So let me go into what it is that we're attempting to do. The goal for us is to make it so that after a worker goes home and or if they move on to somewhere else, they can still make a legal claim. So in other words, our vision is that a worker should be able to seek justice wherever they are, wherever it happened to them, and regardless of where they happen to be moving. Now, unfortunately, there aren't a lot of international instruments, as has been spoken about before, in terms of regulating all of this. So what we're focusing on instead of, say, legal reform is how do we maximize the existing legal systems for as many people as possible. Our context is picking Indonesia and the Philippines, two of the most active source countries in the region, and then Singapore and Hong Kong as test markets. Between those four migration routes, we have nearly 1 million migrant workers, so good enough test bed to work on. The idea is to work at 3 different levels. One is just to work on the logistics of preparing these claims, ideally with some amount of evidence, or where evidence is lacking, pioneering methods of obtaining evidence where we can. That at least leads to bringing a credible claim against an employer or an employment agency. saying, hey, our client has gone home, but they're not going away. You need to pay up. In order to do this, we're partnering with frontline union organizations and community organizations who are at the first step in terms of where workers go to seek help, right? We then work with pro bono lawyers in our destination countries. Now, in other contexts, nonprofits can actually use their own lawyers. We cannot. It's just not legal in Hong Kong and Singapore. So we have to go through pro bono partners. To the extent that that negotiation works, then the worker gets at least some percentage of what they lost back. It's not always 100%, but it's at least something. Then the next piece is if they don't pay up, then we start to go to court. And that's where the second stage of our work really comes in. Even in destinations as developed as Hong Kong and Singapore, judicial officials and even government officials are just not used to fielding claims from workers who are now overseas. So much of their legal system is based on the worker remaining there. And of course, those who exploit workers very much do depend on being able to send the worker home and just kind of wiping their hands of it, right? So in bringing these claims to either labor tribunals or to district court or to small claims tribunals, it's about getting those officials used to this whole process. So a lot of our experience has been about getting those officials from a no to a yes, sometimes with direct negotiation, and sometimes actually going up to higher levels of court to order those lower levels to essentially do what they're supposed to be doing. I think regardless of where our participants are, many of us can agree that there's a huge difference between the law on paper and the law in practice. And where the law really has not been used, you can find judicial systems that are quite resistant to putting them into use. The final piece, of course, is getting to court. That if negotiation and settlement doesn't work, then we go to court. And at least in the destination countries that we work in, court decisions can have precedent and can start to make difference for a lot more workers. I say it's at the top of the pyramid because at least in the context that we work in, 90% of cases settle if they're going to be successful. The other 10% then eventually get wrong. So our overall goal then in this sort of work is to make it so that somebody can go home and to launch this sort of action efficiently, effectively, and affordably, ideally with frontline partners. Because we ourselves, we're a small organization. We can handle about 30 cases at one time. But the goal is to get 10, 100, 1,000 organizations to do the same thing. Now, the reality of this over the last 10 years has been, well, on the one hand, we and our partners have been successful in pursuing most claims against agencies and against employers. When I say most claims, the most major types of claims you can imagine. Overcharging, underpaying, physical abuse, sexual abuse, other sort of workplace violations as well. On the other hand, however, this is not a 100% successful solution. There are gaps in the law. There's definitely gaps in evidence. You also have workers who are very much afraid to bring a claim, either because they're afraid they'll get blacklisted, they try to work abroad again, or they face real security threats from employment agencies back home. That said, even though it doesn't help 100% of workers, it does help some percent and a decent percentage. And our goal, again, is to make it so that the current legal system works as effectively as possible for workers across borders, while the longer-term work of legal reform and in legal development actually starts to take place. And ultimately, the amounts of money that are brought home for workers, while small from the destination country's perspective, can amount to many months, if not dozens of months, of local salary back home. That really has helped workers get through the pandemic. So that, in a very long nutshell, is what we are looking to do as a model. And our hope is that, particularly as we reach 10 years next year, our model can be used in other regions and in other contexts. Now, obviously, it will have to be adapted. It won't work everywhere, particularly where there's major challenges to the rule of law. But that's where we're looking to start. Let me stop here because I realize that time is a bit short.
Thank you very much, Douglas, for this very clear explanation. And to also very much explaining the whole process. We see how challenging it is, and also the capacity you have, as you rightly say, as an organization, and comparing to maybe the task that is ahead of you, and how, in fact, there is in fact a need maybe for taking more cases, but also the capacity, of course, of the organization. I think of the last one of the last comments you made, where you indeed highlighted how, even if it's not 100%, that can make a very big difference for migrants back home in terms of the amount comparing to maybe the local salaries, and that can very much representing months of pays at back home. So I think indeed it's something also to take into consideration and to not underestimate it. But I still have maybe a last questions for you, again, to if possible to answer very quickly is not necessarily the right term, but if you can have maybe a short answer, and then we can continue later on. You work to pursue an individual specific case, but you also working towards strategic reform of the legal system, and to better serve migrant workers, and that is particularly challenging. And how do you see the tension between these goals, and how yet they are complementary?
Yeah, great question, Miriam. And I think it's an issue that just about everybody working in litigation faces. Like, what's best for the client? What's in the client's interest? And what's in the interest of the longer term project? Quick background for everybody who's on the call. Our particular project with the Fair Recruitment Initiative was building up towards strategic litigation on illegal agency fees between the Philippines and Hong Kong. So the idea was this. Both countries have fairly detailed laws around employment agencies and what their rights and what their duties are. The problem is those two sets of laws were never negotiated together. They were very much what was developed in Hong Kong and what was developed in the Philippines. That means that there's gaps, there's overlaps, and there's even contradictions there. So our goal first was to map those two laws separately and then put them together to see what sort of remedies a worker might have. Ultimate goal was to get back as much as possible for anybody who was illegally overcharged. So that's the step one. It'll be available on the Knowledge Hub here shortly. When we get to the actual litigation, however, a lot of times we do see employment agencies just basically folding. They will pay out compensation, or rather than compensation, they'll pay back what they shouldn't have taken in the first place. That, of course, means that we're not getting to actual court precedent. The good part about this, of course, is that the client gets the compensation they need right away. When this action starts to happen in mass, it may have a bit of a change of behavior effect. If employment agents start to learn that overcharging leads to the worker coming back to them, sometimes with a lawyer in tow, it may start to change how much they overcharge, or if they overcharge at all. Of course, it could also just mean that they change their tactics and make it harder to track. But at least we have started to make them change their behavior. Now, there is a real risk that they could see this as just a cost of doing business, at which point we'd have to see if there's a way to increase the penalties, or if at that point really legal reform is needed. Yeah. Now, the thing is, as you said, Miriam, look, if there's settlement, then we don't really see the law coming down on these bad actors. I don't think there's much we can do beyond having a larger pool of cases where that 10% that goes to litigation I was talking about goes from being 10 people to being 100 people, to potentially getting up to mass claim levels. So the next steps, looking over to the next 3 to 5 years, is really looking at putting together larger groups of claims with the idea that a few of them, the really important ones, would get to court. Because we've seen that work in the past, and it's what we're going to have to build towards in the future. But ultimately, as legal advocates, the client's needs do have to come first.
Thank you very much, Douglas, and looking forward exchanging with you in a couple of minutes. There are already some questions for you as well in the chat, and let me then move to our next and last panelist, Ms. Vidya Agarwal from Apple. Thank you very much for joining us. I think it's very early on your side or very late. I don't know which one is the most correct, but thank you very much for for this effort. As we said, at the beginning, we mentioned the role that could be played, in fact, by trade unions, but also directly by enterprise. And I think there are some very interesting strategy put in place by Apple. And what strategy of remedies have been established by Apple? How does it work in practice? What have some of the result of outcomes been according to you?
Yeah, thank you so much for having me first. And just hearing from all the other panelists on all the remarkable work that they've been doing. But there's also a realization of all the opportunities that lie ahead of us. So when we, the private sector, talk about strategies on remedy, it's important to note that we all have a very specific role to play. And one in eliminating forced labor, which for us basically begins with setting and maintaining the highest standards for our supply chain. Our standards often go above and beyond the legal requirements, which many of the panelists have mentioned sometimes are not enough. And that's required to protect people in the supply chain from forced labor risks. Our code and standards and the protections that they provide apply equally to workers regardless of the person's job, their geographical location, or even how they enter the supply chain, whether they're directly recruited or recruited through labor agencies or subcontractors. And this includes a zero tolerance for forced labor. Our policies often start way beyond we even sign a contract with a supplier. And I think that is one of the key strategies post having the highest standard is engaging early. And engaging early with supply chain actors just means being very clear on our policies, our requirements, our expectations, and making sure that we can assess that the prospective supplier actually will be able to meet the requirements, has the willingness to meet the requirements, and we then offer various capacity building and training opportunities for them to be able to set up robust management systems. In terms of recruitment fee and how it works in practice is we all know that this is a very complex issue. Looking at migration corridors, fees that's been paid early on, way before these workers sometimes even reach the labor agents that we're aware of. So for us, one of the biggest things has been mapping our supply chain to really understand where the recruitment journey begins. And based on that, really being able to see that we have a way of not just understanding the supply chain, and the actors in it, but also being able to engage with different levels of supply chain and really work with them on capacity building and understanding the need for mapping, for knowing requirements, for continuous monitoring. And one of the things we continue to do is we hold our suppliers accountable. So once we start, we've implemented, thorough preventative measures. We have independent third-party assessments. Assessors verify that our suppliers are meeting these particular standards that we have. Looking for evidence of forced labor is part of every supplier assessment, and moving to swift action. I mean, I think it's been repeatedly said that there is a lack of evidence that migrant workers can provide on the fees that they have paid. So one of the big parts of our engagement with our suppliers is knowing that when workers report fee, it needs to be repaid, and workers need to be made whole, irrespective of whether they can provide receipts for their for the fees that they have paid or not, because often that's just not available. So I think that makes it extremely important. And then at the end, post providing that remedy and whatever the recruitment fees is, we ensure that this is transferred directly to workers' bank accounts. So our suppliers are required to ensure that that process takes place. And then again, we have a verification system where we ensure that that is actually being completed and that workers are the direct beneficiaries of that particular remedy. And then I think it's an ongoing process. It's not a one-time process. Workers, the recruitment is dynamic. Workers come from different countries, and it's important for us to continue to track progress and report transparently about both the challenges and the strategies that have worked. And I think that's what we continue to do as a company.
Thank you very much for your answer. And can I also ask you, so the role of other important grievance justice mechanisms that must be instituted alongside the repayment model? Do you want to say more on that, Vidi?
That's a really good question. I think there's so much emphasis on the repayment itself, and absolutely rightly so. But you don't know that your rights have been violated if you don't know your rights in the first place. So we believe that protection really starts with rights awareness. And since 2008, we've been ensuring that millions of supplier employees or workers have been trained on their workplace rights. But when it comes to supporting workers throughout their recruitment journey, we also recognize that we need to empower every person in that ecosystem. That includes the labor agents and the suppliers to all take active roles, because they all play a very significant role in that ecosystem. I think it was mentioned that often there's very little trust with the migrant workers have in the institutions and the grievance mechanisms. And building that trust is critical, but which is where engagement with all these actors is really important for us. And I think just going beyond not just grievance mechanisms or when things are going wrong, but keeping channels of communication open. That is critical. Workers shouldn't always have to come only when there's a problem. There are different ways of communication, and we do a lot of work around worker rights. If COVID has taught us anything, is that there is a need and a gap overall for digital platforms through which workers can be trained on their rights. So we've been working over the past 2 years on piloting different strategies and different digital platforms to ensure that workers are trained on their rights even before they leave their home countries, and understand their contracts, and there's transparency in those contracts. Understand that Apple, for example, has a 0 recruitment fee policy, and all fee must be borne by the supplier. And reiterating all of that once they get to supplier sites is critical. So it's an ongoing process of monitoring and also of ensuring that there's the communication and people are aware of their rights.
Thank you very much. Thank you very much for your intervention. Many questions already, in the chat for box as well for you. I still have one question before we opening to the Q&A with audience. So Vidi, how immediate remedy fee into system-wide change, broader change? How can this approach lessons can be scaled into industry-wide change? What is important of industry dialogue to achieve this?
Yeah, that's a big question. Let's try to unpack that. I think in the core of all remedy is that workers need to be made whole, because it is critical for their well-being, and they are the most vulnerable who are directly impacted, the directly impacted stakeholder in this entire conversation. So understanding that direct remedy has an immediate impact on economic empowerment of the worker is what drives us to ensure that workers are paid whatever they are owed, and workers are paid directly and in a timely manner. And that's really important. There are lots of challenges. It's not easy to be able to do that. It is a very complex, it's complex across different corridors. And so what we believe is that it's possible, and we've been able to do it. So we've been able to engage with suppliers and push the requirements for 0 fees and complete repayment. And what we have also done is we have continued to share our challenges, our process, our learnings through that journey, because it's been 10 years since we have been over 10 years since we have been repaying fee within the supply chain. But it's important to share that knowledge. So we have a couple of resources on our website on apple.com/supplier responsibility, which talk about how to calculate repayment, how to be able to make that transfer, how to ensure verification that workers have got it. And we believe that sharing is important because we cannot solve just for our supply chain. Workers in this particular space, these migrant workers, go between different industries. They come from very similar corridors. So you could have workers that have been in very different industries previously and in our industry at this time. So we believe that everything that we learn, we want to be able to share. And one of the things that we have done is, we understood very early on that there is a lack of standardized tools, actual tools that that suppliers can use and labor agents can use to conduct their diligence on whether recruitment fee has been paid, what are the root causes. So we we have a strategic partner with the International Organization for Migration, through which we've worked on the Responsible Recruitment Due Diligence Toolkit, which puts together a series of tools on, calculating fees, how to write a policy, what are grievance mechanisms that you must have. And we continue to work to open source the toolkit and to make it applicable to sectors way beyond ours, because we think collective action is really, really critical. And if the industry together can really, avoid duplication and work towards these strategies of simplifying the tools. I think often we put across a lot of strategic guidance around, repayment and policy requirements. But I think really breaking it down into what does that tracker look like? What does that tool look like? What does a grievance mechanism look like? How do you report grievances is really critical. And I think a lot of the panelists talked about being able to have those in languages that the workers speak. So we've continued to ensure that our trainings, our tools are all accessible in multiple languages, starting with languages in Southeast Asia, and then we continue to expand. And really hope that, that ability to be able to get the right resources, because labor agents want to engage, they want to do the right thing in many cases, but they just don't know how to follow through. And these tools have been helping and empowering them, but also being able to have them in the local language, I think has been a huge learning for us. That helps, that breaks down the barriers for many others to be able to really start on this journey and, really break down into more actionable, kind of strategies versus looking at this very complex problem in its totality.
Thank you so much, Vidi, for your interventions. And I know that you might not be able to stay for the whole duration of the webinars, and so maybe if the other panelists don't mind, I would maybe start to ask Vidi some questions that arrive in the Q&A, because it is now indeed time also to give the floor to our participants, and we received a lot of questions. And the two first questions I maybe want to ask you, Vidi, is coming from participants, Hakim Abdul Salim, is looking ahead, what is still missing from your toolbox on Remedy according to you? And let me maybe he asked two questions. So the second one, you mentioned collective industry action. Which organization are you working through?
I think from what's missing from our toolbox, I think the toolbox continually evolves. Just when we think we've learned a decent amount, there are new opportunities that arrive. I think there's two things. One is being able to have impact beyond our lines. I think there's a question also in the Q&A on how do we impact workers beyond our lines. So making sure that all of the digital worker rights, and as well as the trainings that we provide on responsible recruitment, the tools we provide, are available to suppliers beyond our lines for others that they work with. Same as that for the labor agencies. That is really critical because that is what is going to bring about change. I think that's really, really important. In terms of engagement, I think, again, engaging more with community-based organizations and the labor agents directly has obviously been really challenging due to COVID. We had started engaging with many of the labor agents in the Philippines. Philippines is a critical country for migration, as everybody has mentioned. So being able to engage directly, I think, is something that we want to continue to work on, which I think is critical, because I think the labor agents are not just a critical stakeholder, but their voice needs to be heard. And many of the tools that we developed are in partnership with all stakeholders, including the rights holders, which are the workers, to really be able to make them inclusive and comprehensive. And I think the last thing is just, it's going to be interesting to understand the impact of COVID on migration. And I think the last 2 years have definitely posed some challenges for migrant workers. I think that's going to be really, really critical. So I think that's going to continue to evolve.
Thank you very much, Vidi, for that. We also answered to the questions that was asked by our participants, Aziza Mahood, on how is Apple approach to non-compliance from recruitment agency, and so thank you as well for addressing these questions. There is a question still for you, and then I will maybe move also to our next panelist. How do you widely communicate it to the workers? On the what is the channel you are using regarding particularly the recruitment related complaints?
So involving our suppliers in the entire process is really critical. Our suppliers manage all kinds of grievance mechanisms. Like I said, we map the entire supply chain, and then we continue to engage with different stakeholders. We ensure that it is a requirement of the code and our standards that the suppliers have strong communication mechanisms, including grievance mechanisms. They also have proactive training. So through some of our training initiatives, we ensure that all workers are trained on their rights before they leave their home countries. And that is a 100% requirement. That is a requirement of 100% of our workers. They're then trained again once they reach the facilities. So if any information has been missed in the beginning, it is reiterated by our suppliers. When we do our third-party assessments, that is verified by the third-party assessors, that process is working well, so that we know that there's continuous, that is a continuous process. So that becomes really critical. And I think in terms of understanding I think it's critical to understand that different stakeholders must play their role and have accountability. And that is where, including verification visits, the trainings, the ongoing capacity building, just helps us ensure that the migrant workers really have a say, that they are heard, that they are trained, and we continue to assess our supply chain. And that's not just for manufacturing, that's also for services. And as just the last thing, I know I missed the answering your question on the organizations that we work with. So of course I sit on the ILO's Global Business Network on forced labor, which has been instrumental in just bringing the key actors together and avoiding duplication. I think it helps for us to learn and come up with comprehensive strategies. I talked about our partnership with the IOM. We're also members of the RBA, and continue to push those tools to really bring standardization across the industry, because I think it's very challenging when suppliers and labor agents, especially in the sending countries, have very different requirements from different brands, from different companies. The more we can standardize that process, I think the easier it is for people to really be able to meet these requirements, because there is a standardized ask and a comprehensive ask.
Thank you so much, Vidi, for your intervention. I just want, while I will give the floor to our other panelists, just a last question, but I'll let you answer maybe directly, if you can, in the chat from our colleague Sophia Kagan, who asked if you would be able to share the Apple Responsible labor recruitment toolkit you refer to. If there is a link, something, please, I'll let you put it maybe in the chat for our participants if available. So please stay as long as you can. I know you might have to leave, but if so, thank you so much for joining. But I really hope that you can stay until the end. Otherwise, thank you very much for joining us today. Let me maybe now give the floor to, I'm looking at the question we received. And I would like maybe, Mustafa, to give you the floor to you. We receive a questions. Let me maybe ask you the question. It's in French in the chat, so let me maybe ask you the question in French. Bonjour. This question is coming.
Hello.
Tassing. Bonjour, j'aimerais savoir comment fonctionne.
Hello, I would like to know how work the mobile tribunal courts that you mentioned. Can you maybe
mobile card that you referred in your presentation?
Sure, yeah. And thanks for translating that. That's very helpful. Yeah, so basically there is one example from Abu Dhabi in the United Arab Emirates of the authorities setting up a mobile court system, which does go through the areas where workers live, areas like the industrial area, and allowing them to be obviously registering labor complaints. Also have mechanisms for workers to get educated as to their rights and processes. Now, it's very hard to get accurate information from the United Arab Emirates because of the lack of independent monitoring as to how effective and how widespread those mobile courts are. But I think that they do set a very important precedent because, in fact, on one level, it seems like a no-brainer, particularly in context, which I recognize is not everywhere, where you have large migrant worker populations and they tend to be overrepresented in certain geographies. So that, in fact, something like that can be very, very helpful. But there are actually other initiatives as well by governments across North America and Europe, particularly when they have mega projects and there's links between the state and corporates where they use mobile apps and it's required to get onto certain sites that anyone working on that site has that app and they're advertised quite a bit where they can use those platforms to really provide information to workers about their rights and also give them an opportunity to, lodge any complaints that they might have. So I would say that those are a couple of examples that came up in the research that we did. I think I was a little bit surprised there's not more good practice in that area. But I do also feel that one other thing, although it's not to do with mobile courts, that's relevant, is this, I would say probably emerging. I think it's an emerging practice in countries varying from Germany, Austria, South Korea to regions of the United States, Canada, like New York City, where court and other formal procedures actually have policies, sometimes written into law, where they don't ask for the legal status of a worker when they lodge a complaint. And I think that's a really critical step. I know it's not to do with mobile justice, but why I mention that now, obviously it's relevant to the discussion. But if you think about the concept behind mobile justice, it is about proactively, particularly the state, but also businesses and employers, going out of their way to find people who are in distress, knowing that they exist. And I think that's something that comes really out of the study that I did, which is that really there's a need to be shifting away from formally having some kind of limited ways in which workers can access justice, but knowing de facto that in fact it's not going to work, to actually ensuring, sorry about that, can you get a call on my phone? I've got too many windows open. So just saying that, lastly on that point, that you have to really turn things around and actually assume that there is this issue of exploitation risks to workers, and it includes the recruitment related issues, and then actually proactively looking out to give avenues for workers to get access to justice for any issues that they're facing.
Thank you very much, Mustafa. And we have a question which is also very much related to what you just mentioned, and particularly in the case that, so the question is coming from participant Mr. Konate. It's again in French, so again, let me just say the question in French. And I will maybe invite you, but also Douglas and Mr. Bania, if you want to comment on. Access to justice and the challenges for migrants in an irregular situation. How do you think overcome of the challenges that may be more faced by migrants in an irregular situation? So let me just say the question as well in French. Quels sont les défis quant à l'accès à la justice?
What are the challenges in terms of access to justice for irregular migrants? Some are in danger, and how to actually face these challenges.
Ask maybe Dr. Bania and Douglas just some few words on that, according to you.
Sure. Yeah, no, I think it's a great question. I touched on that in my earlier answer, so I'll be very brief on one very specific example, which I think is really relevant. And then a couple of other points, which are actually policy points that go a bit beyond the report, but I think are relevant as well. The first thing to say is that, for example, in the Chamber of Labour in Austria operates on a membership model under which workers make contributions as part of their social insurance. Now, that system supports all worker members in case of labour and employment disputes with advice, assistance, and legal information. But critically, it's irrespective of their legal status in the country. I personally think that's a really promising step and is something that should actually be rolled out and really promoted, not just by obviously advocates, but also governments and supporters within the state systems, the ILO and other UN agencies, and of course trade unions and businesses, that this is something that works. Why can't it be something that's more prevalent across jurisdictions? And again, it is about saying that someone is a worker, they have rights in the work context, and that this situation that we're seeing around the world of criminalizing people because of their legal status in terms of immigration really hides that abuse. So I think that's one thing that really comes out. I think from a sort of policy perspective, which obviously it's implied in the report, but wasn't really within the remit to go into this space, but it's to say basically that I think there's a real need to have a transnational approach and also a multi-party approach to how we address these things. So by transnational, we've talked about that before, which is that there are issues that workers will face, particularly when it comes to recruitment and the need for access to justice, that won't be necessarily addressed just by where they've come from or where they end up working. And I think that needs some kind of treaty-like, architecture behind that. I think it's, from an advocacy perspective, something we should work on. But I also think what's really come out of the discussion today, and I've really learned a lot from all the speakers, is that there's a part to play for everyone. So you have regulators, state authorities, businesses, employers, trade unions, civil society, and of course, the ILO and international non-government organizations. And so the strategies that we need to adopt around making space for undocumented workers and other workers who are quite vulnerable and the least likely to seek access to justice is to really work together. For example, among other things, and I'll end on this point, Vidi talked a lot about when you have a company as big as Apple, it kind of ticks all the boxes. It's transnational in character. It has the kind of leverage because of its size. And of course, it gets the public pressure, obviously, because it's Apple. So there's an organic sort of interest to an extent to address these issues. And so if there's good practice there, we should learn about that. But I think there's a real need to have fora like this where we're talking to each other to really work out, because the positive thing with all the issues we see around these issues, the positive thing is that we're all on this call today because we really care about this issue. And I think that's a really big positive. We're on the same page when it comes to the need for migrant workers to get access to justice for recruitment issues. So I think I'll leave on that point.
Thank you very much. Maybe Dr. Bania, I would maybe ask you to take the floor if you want maybe to add something on that, and I would also, if you may, take advantage to ask you, I would say, a second questions on what mechanisms need to be, if I may say, need to be placed so to allow for further and more effective decentralization of the process. And in a way as well, that can also help, because there were many questions related to access to justice for migrants in an irregular situation. And how do you think as well, maybe this decentralized system can also address the questions raised by our participants.
Miriam, it's raining very heavily here, so I need to shut my window. So can we go with Douglas first and then I come back?
Yes,
I'm very
please.
happy to cover for you, Doctor.
Please, Douglas, go ahead.
Sure. So I very much agree that we do need international instruments. I find it interesting that we have fairly detailed and complex international instruments for the movement of goods and the movement of money, but not for the recruitment and movement of people, which should be the most important thing there. Now, I feel that project is going to take many years, at least in my own region. I don't know how it is, say, in Africa or the Middle East, but over here, there is very little agreement between destination countries and source countries around the regulation of the movement of people. Maybe if you're talking about high-skilled workers, maybe. But if you're talking about low-skilled workers, there really isn't. So that is going to be a very long-term project, and it needs to happen. Practically speaking, for the time being, if we're just looking at the short term, there's quite a lot of jurisdictions that don't seem to have answered the question of whether labor law and immigration law are connected and should be treated together, or they should be treated separately. So I would invite the participants to also reflect on both their own countries and the major migration routes that link their countries to other places. Good example, by the way, is over in Japan. They have treated undocumented workers as workers first. So if a worker has an issue there and they're not properly documented, they can still go to their version of labor courts. On the other hand, and I think Surya is in a better position to answer this than I am, I remember some years back in Malaysia, that question of whether an undocumented worker could seek justice for labor issues was in front of the Industrial Relations Tribunal and had gone up some levels. Even in places that are advanced like Hong Kong and Singapore, that question just hasn't been answered yet. I bring this up because that's the area where I think we can all make the most impact in the short term, is identifying amongst our destination countries which ones do make that distinction, which don't, and which ones have we not answered the question for yet. The hope, optimistically, is as we start to get these questions answered, we can also start to bubble up with practices that could become a part of more international legal instruments, or at the very least, regional instruments. Because ending with this, these international legal instruments can start from the top down, they can start from the bottom up, and the question is where to begin, or do we begin in both places? Thank you.
Thank you. Maybe Douglas, can I ask you another questions that we have actually in the chat from participants, Adrian Pereira, which is any example of international cross-border litigation, as many migrants are deported even before having a chance access to justice, especially going after traffickers on both sides of the border.
Okay, thank you for that question. And again, I'll just speak from my own particular region. Most of the deportations are not done by the governments here. They are done by the employers and sometimes the employment agencies. They put these people on airplanes and then send them home. Happy to say that we ourselves and our partners do have experiences with people who've basically been disappeared out of the destination country, have gone home, and then we've helped them to reach back out. The limiting factor, however, is if we're talking about criminal action, say for human trafficking issues, a number of the countries we work with really do require the victim witness to be in their country. So if they leave, say, Singapore, for example, they would want that person to come back to Singapore. And for many workers, they have to go find the next job. They don't have time, they don't have the ability to go there. And these investigations can take literally years. So there are still some limitations around access to justice, particularly on the criminal side. We are hopeful, however, that the experiences under COVID, which has basically forced a lot of criminal justice actors to use more online tools, becomes the norm rather than the exception, but we'll see.
Thank you very much, Douglas, for your answer. And so maybe let me turn back to Dr. Bania. How is the sound now?
I think it's better.
It's
It was so heavy. I think I remember the question that was directed to me. So let me respond those.
Yes, please.
And in regards to improving access to the grievance or access to justice-related services, I think it's very important, particularly in the context of Nepal, that the grievance registration system needs to be digitalized as much as possible at the local level, particularly at least at the municipal level. That's very important. And as I mentioned earlier, the referral mechanism, it has to be improved and made more effective. But yeah, it has to do with the resources and the capacity enhancement of the institutions doing these things. And as many of the speakers highlighted, I think it's important to also engage with other social partners, particularly also in line with the principles of the Global Compact for Migration. The whole of the society and whole of the government approach, I think it's going to be quite crucial. And there are also certain issues in the case of Nepal, in which I think many of the stakeholders have been advocating for the amendment of the existing act, which is quite old. It was in 2007 that we enacted that act, and that has to be reviewed and amended in order to provide mandates to the local level institutions for the grievance registrations, handling, mediations, and things like that. It's quite important. Still, the foreign tribunal, foreign employment tribunal, which looks at the unresolved cases or the cases of other kind, it's still in the capital city. So some kind of, I know we are discussing about possibility of decentralizing the services, case hearing services at the provincial or the district level through two means. One, maybe there could be specific procedures or the guideline that can help us provide that service, or that could be done through the district level courts. But it has not materialized yet. But I hope that given that I think the Ministry of Labor, Employment and Social Security here is reviewing the act, and then is in the process of I think coming up with some of these provisions in the new act. But I don't see that it will happen before the upcoming elections of the parliament, which is in 3 or 4 months of time. But that's very important. But one of the critical and very important aspects of enhancing access to justice for the migrants and their family, for me, is without reforming the whole recruitment system and the governance system, labor migration governance system, I think it's going to be quite challenging, because until and unless you have this ecosystem in which the migrant workers have to come to Kathmandu in order to secure the jobs, the system, it's not going to work. So the whole ecosystem needs to be reformed. So what in one of these in relations to that, the discussion is underway here in Nepal about how the recruitment agencies can provide recruitment-related services, or the government entity can provide recruitment-related services to the migrant workers at the sub-national and local level. It's going to be quite critical. Otherwise, it's even very difficult for the migrant workers and even the district or the local level institutions to track the private recruitment agencies which are involved in the recruitment business. So it's quite critical that these services are also decentralized. In relations to the I think the access to justice issues, I think another important thing is, I think many of the previous speakers have highlighted how we can provide support or a free legal support to the migrant workers, both in the origin and in the destination country, is quite important. The government of Nepal came up with the directive to provide the free legal support to those what they call the needy migrant workers, but the implementation of it is not that effective, because the consular officers in the consular services and diplomatic missions are saying that they have to rely on the individual's discretions to determine who is in need and who is not. So I think we have to also make changes in those policies, as also highlighted by Mustafa. And I think one of the pertinent issues that also surfaced in the GCM's intergovernmental negotiation process, we all remember about the firewalls that is needed, both in the case of Nepal as well. Maybe we need to protect the migrant workers, victims, and the witnesses, and in the destinations country as well. So that maybe many of the migrant workers, they've been criminalized in the access to justice seeking process. So how do we protect them in the process so that they can follow the due process, irrespective of their legal status is going to be quite critical. So I think we all have the roles to play in enhancing those firewalls, so that they can access the justice system. In the case of Nepalese, let me add that in the cases like I have some experience from Malaysia and Qatar. The migrant workers, they are provided with some kind of free services by the labor courts or human rights organizations, but without the support for their accommodations during the time that they don't have job and employment. They can't really follow those processes. So how do we provide that kind of support to the migrant workers when they are not in the employment and they don't have resources to support for their accommodation and stay, is also quite critical.
Thank you very much, Dr. Bania, for your answer, and also for your thought on this webinar as well. This is very much appreciated. I want maybe before, because I'm conscious about the time, it's 11:35 a.m. Turin time, and I just want maybe to take, because we still have some questions, maybe to take 10 additional minutes, and particularly also to give the floor to Surya, because Surya, you answered to many questions directly that was addressed to you, to our participants. But I just wanted to ask you also what you thought about, generally some of the comments may be made by the panelists in this discussion. And there is a quite interesting question I found in the chat that if you maybe want to reflect on that, on access to justice, that can very much diverse also regarding the capacity, the skills, and the knowledge from the migrants themselves, and then how it is indeed in access to justice not necessarily reachable on the same way according as well to the skills of migrants, to their knowledge of maybe of the language in the destination country. So I don't know if you want to reflect as well on that, and also maybe some last comments you might want to share with our participants in this panel. Over to you, Surya.
Thank you, Miriam. That's a very interesting question. I would say it is very interesting because often when we speak about access to justice, it's very easy to have a tunnel view vision. It's really easy for us to be overtly focused on giving the services. So we are literally looking at access literally, and we think that that is enough. But then sometimes there is a lack of assessment as to how the receiver of the service is going to view how does it look on their perspective, because access to justice, access to any form of dispute resolution mechanism, right, it first and foremost, it's naturally intimidating for migrant workers. So I very much believe that it has to be friendly. It cannot be intimidating, and it absolutely cannot relate to their immigration status. That is a very unfortunate thing that happens in many countries, where the access is completely interlinked to their status in the country, whether they are documented or undocumented. Then the word justice wouldn't exist there anymore. It's not justice anymore, because then it is not equal. It favors some over others, right? It defeats the purpose. So that being said, language, gender, we have because under MRC we have two projects. One is Triangle and one is Safe and Fair. Safe and Fair is for women, and we see how much more comfortable women are when it's not face-to-face access to justice. That means we have had an increase of women reaching out to us through our online platform, because they are much more comfortable, they feel much more safer, despite the fact that the officers are actually female officers. And language, of course, ultimately, that is one of the major barriers for migrant workers. When they don't understand what is going on, how are they going to be able to contribute to their own process of getting justice? So a lot of times, a lot of them give up because of the language issues. So that is why the awareness, when we do awareness raising, it is very important for it to be in the language that the migrant workers understand. And this is something MRC strives to do. We actually do, I would say, create flyers and outreach materials in main languages of the migrant workers that are in Malaysia, in order to facilitate the understanding process. Because otherwise, I would say there would be a bigger communication breach, as opposed to, even if the language is translated right, there's still a gap. Because then the question is, are we going to ask money from them? What is it in it for us? Very often MRC gets this question, how much do you charge? And we're like, we don't charge anything. And if ever anybody says they charge money as a MRC, you have to come back to me, because it's wrong. So what I would like to highlight is that, as much as I think the panelists, everybody here is so distinguished, and we are all providing the service to the migrant workers, it is really important to have the network leaders, the migrant representatives, giving us constant feedback on the plans that we have to serve them. Because at the end of the day, if it does not resonate with them, if it doesn't sit well with them, or they just don't get it, then all our work, all our effort is wasted. So that is, I would say, the main thing I would like to share with everyone, the main takeaway.
Thank you very much, Surya. And let me also, I think it's very interesting, your last point, and I will maybe give to my colleague who will address in a few moments the closing. There is a very interesting question, and the last question we had in the Q&A, that actually, I could even ask to each of the panelists, and who will fund access to justice? So that's, I think, is indeed a very practical and down to the earth questions. So I will maybe send the balls to my colleague, who will now take care of closing remarks. And I would like to thank each of you for your very interesting thought and participation. We receive a lot of comment in the chat. You have seen many questions and many messages as well, saying that it was very interesting and very inspiring. So if I may, on my side, Surya, Vidi, Douglas, Jivan and Mustafa, I would like to warmly thank you for that. And it was a pleasure and honor to facilitate this session with you. Hope to see you soon in an upcoming session. And without further ado, I give the floor to my colleague, Maria, who is a labor migration specialist and the person in charge on fair recruitment at the ILO, maybe giving some closing remarks. Thank you, Maria, for being with us today, and also for always trusting ITC ILO when organizing this kind of events, knowledge sharing events. So thanks again, and back to you for closing.
Thank you very much. Can you hear me? Yes. Okay.
Yes, loud.
Very well. Thank you very much, Miriam. And well, I will not even attempt to answer the question who pays for access to justice that you're throwing to me. But I mean, certainly when we share responsibilities in the way that it has been described by the panelists over this last couple of hours, I mean, certainly that also means sharing cost to some extent. So I think, there's a lot to reflect on. I will not, of course, try to summarize this very interesting discussion. Just wanted to note that it has been fascinating and an honor to be here with you and with this very distinguished and diverse panel of experts that have bring us a very practical experience, views, lessons, and have been generous enough to share them with all of us. So I know we are running out of time, and I wanted to thank the interpreters also for going over time, and all the colleagues who have been working behind the scenes to organize this meeting. Perhaps just beyond again thanking all the panelists, I wanted to remind participants that this event was organized indeed under the Fair Recruitment Initiative Knowledge Hub event series. And when we're talking about event series, indeed, it means that we have organized events in the past, and we will continue to do so. And as was pointed on the chat as well, we are looking into organizing into the second part of the year an exchange event on the issue of irregular migration, and it's linked with recruitment, but also much broader themes related to migration. So please stay tuned. Do register in the Knowledge Hub. My colleague is putting has put the links to the Knowledge Hub of the Fair Recruitment Initiative on the chat. I would really encourage you to do so, to explore the thematic theme on access to justice. Is one of the priority areas that have been identified as a priority for the Fair Recruitment Knowledge Hub. There will be, there is a discussion forum that has been opened before this event in the Knowledge Hub. I encourage you all to register and participate. There have been so many questions in the Q&A, in the chat, a lot of comments. And I think, our experts has kindly agreed to be available over the next week to reply to question and engage with participants in the forum. So again, please do enter the forum and the Knowledge Hub to continue engaging on this subject. Also, as Miriam has noted at the beginning of this meeting, there are two rapporteurs who have taken notes of this meeting, and will I highlight what are the key takeaways from these meetings, and they will be posting them on the Knowledge Hub. And again, we invite you to reflect on what did you take away from this meeting, and most importantly, as I heard, over and over these couple of last hours, the issue of the importance on sharing knowledge, learning from each other, understanding the subject, coming up with standardized tools. All of this, call for sharing and also for policy coherence is something that we can and we should engage on. And we, through this Knowledge Hub, hope to contribute a little bit to this facilitation role. So I think I will stop there, thanking the rapporteurs. Thank you, Miriam, very much for facilitating brilliantly this event. event. And really thank you all for participating, and I hope to see you soon again. And the recordings will be available in the Knowledge Hub, both in English and French. And again, thank you. Oh, and there was meant to be a poll in this meeting where we would ask you questions like, what do you think are the priorities also that the ILO should follow up on. We didn't have the time to have it because of the risk discussion today, but we will put it on the forum. So again, you will have the opportunity to answer this questions, suggest what your priorities are. And the forum also has a feature that allows you to suggest theme or issues that you would want to see featuring in ILO webinar events in the future. So please, again, do not hesitate to reach out to us and suggest topics for further discussion. Thank you, Miriam, and thank you everybody who has worked behind the scene for this meeting to be successful.